is a fatal flaw of some kind in the law, which a court later determines. And Congress has made it very clear that if that flaw exists, it doesn't want the rest of the law to survive. That's known as the inseverability doctrine. It turns heavily on congressional, the purpose of the law, congressional intent behind the law. It is really delving into sort of a psychological study of Congress. Would Congress have wanted this law to survive if this particular piece of the law fell away? So that's point number 2. And point number 3 is that if you want to go to court to challenge an act of Congress, you have to have what's known as standing. You have to have a legal injury. And that's where we really see the courts paralleling a true field of battle. I mean, you want to go onto the field of battle, you better have a legal stake in the outcome. If you just don't like a law, if you're complaining about a law, if you're angry about a law, then you can't go to court. You have to have legal standing. So those are the 3 legal sort of backdrops. And then the factual backdrop is as follows. If you remember back, 2017 wasn't all that long ago, although I know it feels like several lifetimes ago at this point. But if you remember back to 2017, in 2017, we had this phenomenal battle royal over the repeal of the Affordable Care Act. The Trump administration and its supporters in Congress tried throughout the spring and summer to repeal the Affordable Care Act. The full repeal passed in the House. And in the end, on this magical day in July, late July, at 1:30 in the morning, Senator McCain very famously came onto the floor of the Senate and gave it a thumbs down, and that was the end. Nobody was going to try that again. It was just too painful. This was sort of the turning point for the Affordable Care Act. Everybody suddenly loved the Affordable Care Act. They loved the Medicaid expansion. They loved the subsidized marketplace. And of course, it didn't help that the Congressional Budget Office, which estimates the effects of changes in law enacted by Congress, didn't help that they pointed out that over 20 million people would lose coverage. So that was the end of that. But it so happened that later that fall, Congress did something that they all loved and that sailed right through in a hurry, which was a major tax reform bill, the Tax Cut and Jobs Act of 2017. And in the tax reform bill, Congress took the so-called individual responsibility provision of the Affordable Care Act, which is the thing that says if you have affordable insurance available to you and you don't buy it, you have to pay a tax penalty. There's a lot of places in the tax law where you can either do X and avoid a penalty, or you can do Y and create a penalty and impose a penalty on yourself. You have a choice. It's not a very nice choice if you don't want to do either of those things. But in fact, the Affordable Care Act, far from being a mandate to buy insurance, because Congress cannot mandate that you buy insurance, but they can attach a penalty if you don't. So Congress took the penalty, which was set at the full penalty is a couple of $1,000s, and they turned the penalty down to 0. They imagine a dial on a radio. They dialed it back to 0. So the penalty stays on the books. It's just set at 0, and it's set at 0 for the indefinite future till they maybe want to dial it back up. So that's what happened. And when they did that, the members of Congress were very careful to make clear that they had no intention of touching anybody's insurance under the Affordable Care Act. They just wanted to give people more choices. The history, the structure, everything didn't matter. As soon as the penalty dropped to 0, opponents of the Affordable Care Act raced to court in what has now become an infamous location in Fort Worth, Texas, where they found a judge who has been sort of presiding over a lot of cases challenging the Affordable Care Act or pieces of it. And he declared the entire law unconstitutional because there was no tax and therefore no constitutional exercise of taxing powers. The penalty was 0. And he immediately declared that because in 2010, the purpose of the law was to connect all the market reforms and the other changes to this requirement to buy insurance, that given the 2010 intention of Congress as opposed to the what was then by then the 2017 intention of Congress, he declared the whole law null and void. It got appealed to the Court of Appeals in the Fifth Circuit. They agreed with this constitutional assessment, but they took a look at this sweeping order nullifying the whole statute. They said, whoa, wait a minute, we're going to send it back to you and let you do a much more careful job deciding which of the 1,000 pages disappears. And at that point, the Supreme Court reached down, grabbed the case, said enough is enough, and now I turn it over to Joel for the play-by-play.
Good afternoon. Well, thank you, Sarah, for kicking us off. I'm going to take 7 or 8 minutes to provide a blow-by-blow of the oral arguments. So if you haven't had a chance to listen to the full 2-hour argument and you don't plan to, this is basically distilling that down into about 7 minutes. So during Q&A, we can flesh out any aspects that you all like. I'm going to take the arguments in the order of standing, constitutionality, and severability. So standing refers to the ability of a party to demonstrate sufficiently that they have been harmed from a law that's being challenged. And without standing, a lawsuit will technically be thrown out without consideration of the substantive merits of the case. So last week, interestingly, more time was spent on standing than on severability, and it was discussed in 3 different contexts: individual standing, state standing, and what was called standing through severability. So the 2 individuals who are challenging the mandate maintain that they have standing to bring the lawsuit because they have to spend money every month to comply with the command to buy insurance. But the California Solicitor General, and that was Mongan for those of you who are listening, contended that the individuals lack standing because the mandate does not create a legal command. And in any event, because there is no threat that the mandate will be enforced against them, a requirement that has been needed to satisfy standing in prior Supreme Court decisions. The Texas Solicitor General, and that was Hawkins, claimed that the states have standing to bring the lawsuit because the mandate increases their costs as well. For example, because some people comply with the mandate by enrolling in the Medicaid program in Texas and in other states. And of course, there are costs occasioned by mandate-induced IRS administrative paperwork. Mongan responded by saying that even if that might be theoretically enough to establish standing on the part of the states, that the states had simply not in fact shown that their costs had actually increased. Arguing on behalf of the House of Representatives, Don Verrilli, who of course had defended the law back in 2012, was less willing to acknowledge that the states might, in some circumstances, have some legal right to sue because of the paperwork burdens imposed by the mandate. He told the court that those reporting requirements flow from other provisions of the ACA as well, and not just from the mandate. But much of the standing discussion focused on a theory suggested by the Trump administration, which argued that the challengers have a right to sue because they are injured by ACA provisions other than the mandate itself, but which are nonetheless somehow tied to the mandate. Then goes their argument, if the mandate is unconstitutional and if the mandate is inseverable, the government could claim something termed standing through inseverability. Justice Roberts was particularly skeptical of this notion, saying that the theory really expands standing dramatically. He says, quote, I mean, just in this act alone, you're talking about almost 1,000 pages, and you're letting somebody not injured by the provision that is challenged to sort of roam around through those 1,000 pages and pick out whichever ones he wants to. Justices Thomas and Kagan were also openly skeptical of this argument, but other justices landed somewhere along the spectrum. Let me turn to the constitutionality of the mandate, which actually received relatively little attention. Several justices pressed Mongan and Verrilli to explain how the mandate could still be valid, given that the mandate was justified in NFIB as an exercise of Congress's taxing power, but also given that the mandate no longer raises any revenue. Justice Breyer suggested something different, that the mandate now simply looks like many other laws that exhort people to do things, like his examples, buying war bonds or planting trees for the betterment of the environment, but which lack an enforcement mechanism nonetheless. Justice Kagan also appeared to side with California in the House of Representatives on this issue, noting that the court ruled back in 2012 that the mandate was then not an unconstitutional command, and that the 2017 penalty, zeroing out the 2017 penalty, only made the mandate less coercive. Justice Sotomayor asked the DOJ lawyer, and that was Wall, a series of questions about whether Congress has the authority to delay, extinguish, or restart taxes, and Wall responded in the affirmative. When pressed on the difference between those types of taxes and the ACA mandate, Wall responded that the other examples are quote unquote naturally written as taxes, whereas the ACA mandate was only construed as a tax by the court in NFIB and was not necessarily intended as a tax by Congress. As a result, according to Wall, the mandate can no longer be construed as a tax absent the penalty. In an exchange with Justice Alito, Verrilli emphasized the need to focus on the fact zeroing out the penalty is a, quote, very strong textual signal that Congress no longer believed that the penalty was needed in order for the markets to function. Overall, it's kind of hard to predict how the justices would decide the constitutionality question should they even reach it. Some apparently view the mandate as a still legal choice about whether to purchase health insurance. Others view it as a now unlawful command to purchase insurance, while other justices seem to view the mandate as simply inoperative. Finally, turning to the question of severability. So if the court reaches the constitutionality question, the issue of severability could obviously take center stage in its opinion. But in a surprising twist, Justices Roberts and Kavanaugh appeared to extinguish the hopes of Texas and the Trump administration, as both justices made comments suggesting that if the mandate were struck down, they were inclined to leave the rest of the law in place. This part of the oral argument started with several of the court's more conservative justices, and that actually includes Justice Roberts, noting that in NFIB, the ACA's defenders argued that the mandate was the law's cornerstone. Roberts recalled how the court was told that the mandate compelled people to buy insurance so that the rest of the ACA system could survive, but now the law's defenders were saying that the ACA is operating just fine without an enforceable mandate. In response, Verrilli explained that the 2017 Congress asked the Congressional Budget Office what would happen if it reduced the penalty to zero. And the CBO responded that the effect on the insurance market would be the same as if Congress eliminated the mandate altogether. Roberts then told Hawkins that in light of the 2017 amendment, it would be hard for the challengers to argue that Congress intended the entire ACA to fall when that Congress did not repeal the rest of the act itself. According to Roberts, invalidating the entire ACA should be Congress's job and not the Supreme Court's. And then finally, Kavanaugh explicitly told Verrilli, quote, "I tend to agree with you that it's a very straightforward case for severability under our precedents, meaning that we would excise the mandate and leave the rest of the act in place." So with this backdrop in place, I'm going to turn things over to Bethany, and then all three of us will come back around and talk about what are the possible outcomes going forward.
Thanks, Joel. Thanks, Sarah and Dean Goldman. So my role here, although trained as an attorney and working at the intersection of health and justice, is really have some reactions. And I think in the interest of full disclosure, I should let you all know that I used to work in state health policy. And so we saw a lot of this play out. So as a first note, what you heard Professor Rosenbaum walk through was the history, what led up to this, and why, as Joel walked through, why we saw certain arguments raised, which really brewed from the lead plaintiffs here, Texas, as well as some other red or conservative or Republican-led states. So in terms of standing first, I just want to make note that it's important to distinguish that there were individual plaintiffs as well as your state plaintiffs. And so the two individuals, there was some light touch on standing, but for when I was looking at, or rather listening to the arguments, I was still looking for more to be explained related to the individuals who were made party to the case. Secondly, as to the states, there was quite a bit of focus. And so I would ask you all in the audience to, as Sara, Joel, and I talk and opine more on the states like Texas, arguing that paying for more people to be enrolled, and the reasons why I'm bringing this up in a moment, but paying for more people to be enrolled or having those additional paperwork requirements for folks because of the ACA's additional coverage, that's where they claimed there was harm. Consider that action that Professor Rosenbaum played out as she helped walk us through the actions in Congress in 2017, and think about the CBO report that was referenced in the arguments and what the CBO made note of and what relevance that had in the argumentation. So remember, there are individual plaintiffs, about 2 of them, I believe, and then there were the states that basically argued that the rest of the act still continued to result in a burden. What ended up happening with the standing arguments is that I noticed that several of the justices, including Justice Thomas, kept coming back to the issue of constitutionality and severability. So there's clearly a lot of skepticism about whether you could even continue to make the one argument without the other. Like, are we actually getting to the merits? Here, several of the justices continue to force or move past the standing issues and talk about the merits of the case. So Sara and Joel, I'll ask that we talk a little bit about just procedurally, like why the justices continue to go back into having no choice but to discuss the actual merits related to constitutional and severability. And then landing on finally severability, as I, in a policy shop, formally had to explain this case to folks. I explained it as we saw for years actions taken in Congress to really, I think, drain the blood in the arm of the body being the ACA. Then we saw in 2017 through the Tax Cuts and Jobs Act, the arm was finally drained. And then when the case was filed, the folks who brought the argument that the case was unconstitutional said, oh, well, the arm's dead, so is the whole body, throw the entire thing away. Yet the body can have its continued operations without the arm, just amputate, if you will. And in this case, one can say that by zeroing out the penalty, the tax penalty aspect, as Congress can, and you saw this in the arguments, occasionally Congress may, or even through an executive order, the IRS may reduce a penalty of a tax one year, and then, as you saw in the arguments, Congress may decide, hey, we're going to increase it again. We're going to use that penalty as a lever back and forth. So using that analogy, as gruesome as it may have been for folks, that's in fact how I would explain to folks that you have the ACA still standing and walking. It is limping its way into 2021 during and through a pandemic. I know Dean Goldman's like, where's she going? It is limping. The ACA is limping its way through 2021. And so my continued reactions are, where are we right now in terms of open enrollment? While these arguments took place, we also had the beginning of another open enrollment period. And so the public's perception of, speaking of harm, is there in fact harm that occurred as a result of the ACA, or as a result of the zeroed out penalty, or the penalty, or rather the individual mandate still in existence? Where do we see the perception of harm for the general public in terms of enrolling in coverage through the ACA? So I'll pause there. Hopefully that made sense to folks, and ask my colleagues here to continue with our opining.
Can I ask Bethany a question, actually? So as a former state person myself, one of the things I found fascinating is that there are states on both sides of this case, and how that plays out amongst the states in terms of their deciding whether to join in a case like this or not, which side to take, and how it could be that, you know, there's states that find this harmful, other states that find this beneficial, or, you know, maybe you could explain that to us as a state policymaker yourself.
Great question, great question. And so let me say this first. Remember, for folks who are studying the Affordable Care Act, and you hear the public sort of trying to remember, what did the Affordable Care Act get done? Remember, Medicaid expansion and then you have your private coverage in NFIB. NFIB made the Medicaid expansion optional for the states. And so when we saw, I think it was about 18 Republican-led states oppose the ACA or take fall in line with Texas to oppose the ACA in this California v. Texas case. Some of them were non-expansion states like Texas, and a couple of them may have been. So there was that additional cost that those states may or may not have taken on by expanding Medicaid. But what you saw in the arguments was that Texas, the folks who opposed the ACA said, but we also had the burden, as Texas is a non-expansion state, just brought on through having to administer the private coverage aspects of the Affordable Care Act. So for example, you see the notices that come out with their insurance, with everything from Section 1557, non-discrimination in healthcare notices, things like that. The state of Texas was saying, this is an additional costly burden on us. And there was a CBO report that was referenced in the arguments to sort of back up the factual claims in that regard. I'm not saying that those were legitimate or even worthwhile arguments to make, but in fact, that's where you could see the states led by Texas arguing that in the state policy context, this is a cost to us, and so we are still therefore harmed by the entire ACA. However, this case rested on just one section of the Affordable Care Act, Section 5000A, the individual mandate, and the individual mandate never disappeared. It was just that the penalty attached to it was zeroed out. Hence our circle back to standing.
Well, and the other thing the justices really didn't like was the point that Joel was making about sort of conflating the consequences of not striking down the law with standing. In other words, they're harmed to the extent that states are harmed by having to give people insurance or, help people document their coverage or bring their own programs and services into compliance with a civil rights law. These are the harms that Texas is talking about. The court was bothered by the fact that these are really not standing arguments. They are, if you don't overturn the law, then we're going to be harmed. But that's different from saying we're harmed by the tax, by the individual mandate. That the state is not subject to the individual mandate. And so the justices were irritated by this. Joel, I don't know if you want to say anymore, and that's where this issue came up with Chief Justice Roberts saying, if we let you bring this case, then there are going to be all these people who don't like laws roaming around inside big complicated laws, looking for things they don't like, and then coming to us and saying, we're hurt. It's a consequences argument. It's really not a standing argument. So.
Yeah, and let's not forget that many conservative legal scholars who have been on board with all of the ACA cases up to this point have effectively peeled away from this case because they find the arguments to be somewhat preposterous. And that's in part standing, and it's in part constitutionality, and it might be in part severability. But there's no question that irritation was coming through. And I think it was the chief who multiple times was sort of pointing out to the lawyers who are arguing on behalf of Texas and the DOJ that you may not like this kind of standing approach going forward. Like you're potentially opening up a door that you are going to regret down the line. So it's somewhat phenomenal that they were looking to open up that door just for this case. I think it goes to show you just how desperate and interested they are in finding some avenue to strike down the ACA.
Right. The other interesting thing, of course, is the point that Bethany raised, which is, okay, so what are the possible results from this case? And, if you want to game it out in your head like a chess match, what might happen next? So one thing that could happen, of course, is that the court simply throws the whole case out on standing, says the individual plaintiffs had no beef because they still have a choice. It just gives them more choice. There's no mandate. They're not compelled to do anything. And to the extent that they think that because the law's on the books, someday they could be compelled is nonsense. That's just too speculative to be standing. And the states, for the reasons we just talked about, don't have any standing either. You know, they're just in here belly aching about a law they don't like. That's the end. All is forgiven. We just forget about the last 3 years worth of litigation, and here's the Affordable Care Act on the books. So I think probably it's interesting. A couple of legal observers, you know, who do a lot of writing and thinking about the Supreme Court, have sort of said that's the likely result. We were talking when we were preparing for this seminar. A couple of us made the observation that, you know, you could feel, if you even just listened to the argument, that the justices were really irritated by this case. This is time number 3 for them. They have been around the bend on this thing before. You know, here come some more people moaning and groaning about having affordable insurance. It's the middle of a pandemic. What are you doing? And they could just decide to teach everybody a lesson and throw the case out. I tend to think that's not how it's going to roll, but who knows? Then another possibility, which I think people really don't think is going to happen, is that they find that the change in 2017 makes the law unconstitutional, and they throw out big chunks, if not the whole law. And I don't even spend time really worried about that, because I don't think that's very likely. I don't know how Joel and Bethany feel, but it just didn't seem to be in the stars because of what Kavanaugh and Roberts did in the middle of this oral argument. They basically turned to the United States and said, you lose, and to the states and say, you lose. We're not throwing this law out. I'm inclined, you know, to basically walk away from this thing, because and the Chief Justice said, you're just trying to get us to do Congress's job for it. If they wanted to repeal this law, they could repeal this law, and they didn't repeal the law. So in which case, everything is sort of left the way it is. And then what happens at that point is, okay, does everybody now settle down into some political nirvana where we can at least talk about some of the modest improvements that ought to happen, like making coverage more affordable, like doing something about the 12 states that continue to refuse to expand Medicaid? Do we create an alternative for those people? Do we give people relief from the high cost of prescription drugs? You know, all these things that have been talked about. Do we move on in Congress, or is Congress just so riled up from this election that the Senate refuses to do anything? In which case, what we're probably looking at is years of the president trying to do things administratively, just like President Trump has tried to do things administratively. And there's a fair amount he could do administratively, but not nearly what we'd need to make coverage more affordable and costs lower. So,
and if I can, in fact, these sorts of uncertainties created by the cases, these sorts of uncertainties created by the administrative measures taken at the federal regulatory level, and that we saw play out in the Section 1115 and Section 1332 waivers, have, I think, actually driven up costs. And they have, I think, deteriorated the adequacy of the networks, all the sorts of things the ACA sought to prevent, which is to ensure that people had choice, the very things that they talked about in the arguments. If I can, Sarah, there was one point you mentioned also about the individual plaintiffs and choice. And Joel, if you don't mind, since you're a little bit closer to the notes on the arguments, there was at least one of the justices at least went back and forth to press further on this notion that once the penalty was zeroed out, then there was somehow harm created by that, as opposed to just prior to 2017, before it being zeroed out, there was no harm alleged. So it was very absurd to argue that you had a more coercive, I believe that's some of the language that was utilized by perhaps Kagan or Sotomayor, that suddenly you have a more coercive individual mandate now that it has been zeroed out. It's hard for me to even explain that. My mind is going around in circles just trying to explain it. It just further weakened and makes me think about the confusion that's right now in the public's mind with regard to the need to sign up for coverage on top of everything else that folks are trying to manage right now.
Yeah, we have an interesting question from Susan Wood to everybody, which is, what did we all make out of Justice Coney Barrett's questions? She, I think, like a lot of new justices, was not a particularly aggressive questioner. I don't know, Bethany, Joel, do you have any thoughts about her questions? What you see most interested in?
Yeah, so I agree. I think based on her questions, which were really low wattage, she was taking sort of a lay low approach to this one, either because she knew potentially how the chief and Justice Kavanaugh felt, and this was not going to be a battle around throwing the ACA out or not. And also because it's not a totally untypical approach to one's first oral argument. She came across, now she is of course a former law professor, and I think she came across somewhat professorial in her questioning. I also would never attach any meaning to how she behaved in this oral argument as to how she might behave as a justice going forward. I just don't think there's enough of an end there to know anything about the kind of justice she will be. I think it's much more reasonable to look back at her past writings and her past opinions to see what kind of justice she might be. And if you've done any reading on her background, I think we have a pretty good sense of that. So my guess is she was more low wattage in this one than she will be going forward.
I was actually hopeful when I agree. I made a specific note as to her comment pertaining to finding that it would be odd to construe that Congress would pass a law in a way that would make the law unconstitutional. And so I was hopeful in that regard that she was not falling out of line with where the other justices were going.
Yeah, no, I felt, of course, during her confirmation hearing, she basically signaled that she wasn't about to strip, 20 million people of insurance and 150 million people of market protections. This is not why, in her view, she was being elevated to the court. It's interesting because we now have this term, not foreseeing her appointment, but this term, the court has a number of public health versus religion cases. Mm-hmm. And I think probably we're going to want to watch these cases very closely and do another webinar when the decisions start coming down. One that is not directly public health, but it touches on the same issues, which is government police powers versus religion around the issue of whether the city of Philadelphia can bar foster care placements with bar Catholic Association from being involved in foster care placements because they will not place children with same-sex couples. Mm-hmm. And the other, which is even more directly on point, is whether to uphold the refusal of a couple of states to make a religious exception to general public health pandemic protection laws. I mean, in that case, we are getting very close to the Jacobson case, which I is one of the reading staples for all public health students. What are the powers of public health? To protect the public's health, and through impartial laws that affect everybody equally without the need to carve out exceptions, especially in public health emergencies. And so, and very interestingly, in that case, the Chief Justice, in refusing to provide temporary relief to one of the appellant churches, said very pointedly, I do not want to see the courts second guessing government officials about what to do in a public health emergency. Well, that was, of course, before potentially he was dealing with a 5-4 majority in favor of a religious exception. So this will be quite something if in the middle of a pandemic, once in a century pandemic, suddenly we have all kinds of First Amendment limitations on the power of public health to intervene. So, but she was, I agree completely with Bethany and Joel, she was very much sort of a quiet presence, unlike Justice Sotomayor, who I thought was the most astute questioner. I thought her question to the solicitor, the United States solicitor, about, well, what would happen if Congress passed a law that, turned down the penalty when the market was robust and turned it back up if it faltered. I don't think he had, as we just mentioned, I don't think the answer was particularly good. And I think she's going to make it very hard for the court to find that that's not a constitutional approach to taxation, to vary the size of a penalty. So we could see this whole thing, with the court just saying, yeah, you have standing, and guess what? This law is perfectly constitutional. So. I think one of the most interesting aspects of all of this is sort of what the Biden administration does in the interim, right? So it could be that the court will mercifully do whatever it's going to do fast. We're used to, now we all, especially we lawyers, all spend June logging on to this very famous website, SCOTUS blog, where on days that the decisions come down, everybody's logging on and refreshing and refreshing and refreshing to see if the decision has come. Well, in this case, if the court, wants to be more sensible and practical, it's going to issue its decision, especially if they're going to leave the law alone. Whatever they do, they leave the law alone. Then why would you make the new administration, sit around not knowing what to do? In the interim, you'd want to issue the decision pretty quickly, so a new administration and a new Congress can sort of start the wheeling and dealing over whether there's going to be a legislative package or not. So it's not just what are they going to decide, but how fast do they decide it? And once they decide it, then the world's going to be awash in speculation about what everybody's next move is. Is it trying for some legislative stuff, not trying for legislative stuff? The one of the really thorny problems is that on the people who are in the dozen states that have been left out of any insurance coverage because of what the court did in 2012, it made the mandate optional, the Medicaid expansion optional with states. We have these dozen states with millions of people, disproportionately African American, I would note, because of where these states are. And in many ways, the options are now even more limited because of the political split in Congress. The logical thing to do is to set up a federal default system and let states that don't want to opt in just, let the people in those states go into a federal default. There's a headache about how do you keep all the states from jumping ship at that point. but you know, the worst is that everybody who's very poor would get a marketplace plan and then maybe some supplemental Medicaid coverage. Well, if there's not going to be any legislative action, or if the action is going to absolutely refuse to do anything about those 12 states, then we have this continued horror show of millions of people in 12 states with absolutely no way to get affordable government insurance. And the betting is that what the Biden administration will do is really start trying very hard to use its experimental authority, just the way President Obama did, to sort of lure these 12 states into doing something for these people, even if it's not the full expansion. And so that's one of the most closely watched issues of all, because the disparities here, you know, the inequity effect is just so astounding whenever people are confronted with it. But only time will tell. I see we have a couple. Oh, sorry, sorry, Dean Goldman.
Yeah, I was going to make note of the questions as well.
Do you want to tackle them, Bethany?
Yeah, right before tackling some of the questions, Sarah and Joel, I know when we went into the filing of this case, there was a request to expedite it. And now here we are again, right, where we are, it was pre-COVID, and we're in a situation that may very well dictate expediting a decision, a combination of COVID and I think the elections
right.
that are dragging on. So I would just put that out there. But there are, in fact, a couple of questions. So Thomas's questions. What did you all make of Thomas's questions about standing and challenge the mask mandates? And apparently Alito's mask mandate comments that were also made during a Federalist Society meeting.
That was an astounding thing. I don't know how many people happened to read what Alito did, but he basically gave this speech. You describe it, Bethany. What did he do?
You go, Sarah. I will not be able to refer.
Well, he gave this speech that basically boils down to, in the name of religion, I should be free to discriminate against same-sex couples. I should be free to infect other people. I should be. It was a diatribe about the disrespecting of religion. So it goes right back to this case that we just talked about, having to do with public health and the applicability of public health protection orders applying to churches. Right. And the thing that was so amazing about it was how blatant it was, that he there was no other way to understand his comments, as far as I could see, but in the name of religion being free to be quite discriminatory.
That's what we saw in the 1557 cases that were coming up through the same exact circuit. So that's where
sort of a grievance-filled speech. So Thomas's questions about standing to challenge mask mandates. Does anybody have any thoughts about that?
I think he and Alito too, in his comments to the Federalist Society, I think they're just angry about the mask mandates. And I think he was just simply trying to raise a point. I don't think he was a very good hypothetical legal question pertinent to this particular case. I think he was just simply trying to make a point.
Yeah. Yeah, I think he was, there's justices, of course, question through hypotheticals. They love to do that. And of course, that's the way law works. And law is very grounded in the facts of a particular case. But it was not, unlike Sotomayor's question, which was extremely good, the hypothetical she posed of a sort of a fluctuating tax law. This one kind of was beside the point. It's an entirely different situation. And of course, that's closer to eating your broccoli, which we already know they've said you can't do. How about the question from Brian Walsh here? We have two. We have one from Maureen Burns. How fast have the courts? Well, remember Bush v. Gore. They didn't waste any time in Bush v. Gore. They decided that one pretty fast. They vote. They basically meet. The argument was on the 10th, which meant they met in chambers literally that Friday. and did a preliminary poll of where the justices are, they don't waste a lot of time, and then they assigned whoever, depending on whether the Chief Justice was in the majority or not, he would have probably would have assigned it to himself. If he was in the minority, then the senior justice in the majority gets to assign the opinion. I think they're going to look for, and we'll have a lot of concurrences. For example, if they find standing and they find unconstitutionality, but severability, so the law is saved, I bet you we'll have a bunch of concurrences from the liberal wing saying, well, I would have found that this whole thing was still a constitutional law, but I'm going to go along with the Chief Justice. So, but I think we're going to see something like a 6-3 decision or 7-2. We're going to see Thomas and Alito for sure, and maybe Gorsuch. But I think on this one, I don't think Gorsuch wants to disinsure the whole world. He was sort of not particularly active in this case.
No, I agree. And that's my thinking too, is I think last week when I was talking with my students about this, I was thinking maybe 7-2. And just to comment about Maureen's question very quickly for some listening who don't know, yes, they've met in chambers now on the Friday after the oral argument. But as many of you know, the Supreme Court seems to very much like to shield itself from public display as much as possible until the end of June, when they want all of the drama. And so certainly in past ACA cases, they have not raced to get the decisions out. They have held them until late June. And I think to Sarah's point earlier, this is probably a case, especially if they're kicking it on standing grounds. There's nothing particularly sexy about holding a case until the end of June to tell everyone that no one had standing. And so while they don't typically move with haste on the bigger cases, and I think going into this case, we all thought it was going to be a bigger deal, but now given some of the questions and comments, we think not. So my guess is like Sara, I think it's going to come relatively quickly. I think certainly by spring break we'll have it.
Yeah, I mean, I think it depends on how kind they want to be to an incoming president, with a lot on his mind already. And on top of everything else, he's got to deal with 20 million people losing subsidized coverage overnight versus, it takes time. The last question we have, I know we're almost out of time here, is from Brian Walsh. Brian has a really good point, which is if you really want to drive a stake through the heart of these cases, do you decide it on a preliminary matter like standing and let them continue to fish around for yet another basis for bringing a suit? Or do you say, essentially put up a banner over the court saying, this time we really, really, really mean it, don't come back? I would say probably my answer to Brian is I'm not sure anything would dissuade people from continuing on this path, but I think the very fact that the court reached down and took this case, and said, we're just tired of this. It's not going to go to, not everybody's going to go live in Fort Worth for the next 70 years trying to figure out what's severable and what's not severable. We have to end this. You decide cases narrowly, although any law professor would tell you that standing is one of those things that's in the eye of the beholder. So when they want to find standing, they find standing. When they want to tell you that nobody has any standing and duck a case entirely, they'll do that too. So I don't know what Bethany and Joel think about.
That's where I found it most difficult to make any reads, which is why I started some of my commentary with just distinguishing that there were both individual plaintiffs and the state plaintiffs. And that is why we saw the arguments. That's where most of the time was in fact spent in really drawing out through various hypotheticals, the arguments in that regard. So hardest tea leaves to read are, as I think they historically are, on standing issues.
Yeah,
and apologies, we're supposed to read. Can you, Joel,
yeah,
can you
exactly.
just repeat the question?
Let me read it and then I can comment. So Zoe asked us to repeat the question. Basically, Brian was asking that if the court throws the case on standing, aren't they basically opening the door to continued litigation on the merits? And Brian, you read my mind. I was thinking this earlier, but I didn't get a chance to jump in with a comment. I think this is where the court's in a bit of a bind, because I don't think they have a smooth standing argument that they would like to use in order to let the case go forward to the merits. As we talked about earlier, some of the standing options are pretty unattractive to the court. And so I think they're worried about, and so Sara, you were saying earlier, and I generally agree, which is I think there might be enough justices to kick it on standing. I'm just not sure, like Brian, that they want to do that, because then they know they're going to see ACA 4 at some point in the not too distant future, assuming someone can find a way to, get a foot on the rung of standing. Right. So I do find this one to be a bit of a challenge. So I don't know what they'll do, obviously, but Brian, I think it's a fair point.
I do know that Nick Bagley is very convinced, and he of course is quite an astute Supreme Court observer, and he was doing lots of blogging, and he clerked he clerked at the beginning of his career, and I think he clerked for Breyer, and I think he was really convinced that they just had not made out a standing argument, and that this court has too much of a track record now, a very conservative court. One of the ways that conservative courts play themselves out as conservative courts is they slam the door in people's faces. You don't have a right of action, you can't be here, you don't have standing. And suddenly to let all these folks in based on flimsy arguments, as Joel says, sort of really cuts against the grain. So we shall see. And I think that's it for questions. We are right at 1 o'clock.
Are indeed, and I can't be more grateful to the three of you for such a brilliant discussion, Bethany and Joel and Sara. That was wonderful. And thank you so much. I think I learned a ton about what happened, and actually I was very surprised by it. It's not exactly what I expected, but thank you so much.
Well, we'll be back when we've got a public health case. We'll be in touch with the dean.
When we get the mask case.
Exactly.
Thanks so much.
Bye, all.
Bye-bye.